As a real estate agent, one of the biggest mistakes that you can make is not understanding tenancy types, particularly when dealing with a probate listing. My name is Sharon Smoot. I'm a realtor and a residential real estate closing attorney in the Metro Atlanta area. And today I want to talk to you about tenancy types, specifically because we're in Georgia, tenancy in common versus joint tenancy. There is a third type of tenancy called tenancy by the entireties. It is not recognized in Georgia. As a matter of fact, I think it's only recognized in two states. So I'm not even going to touch on tenancy by the entireties. But let's talk about tenancy in common versus joint tenancy when dealing specifically with a probate property. So Mary and Joe own a piece of property together. If Joe dies, one of the most important determining factors in whether the house can be sold without the need of going into probate court is how Joe and Mary hold title. If Joe and Mary hold title as joint tenants with full rights of survivorship, Mary can go ahead and sell the house. Nothing needs to be done. At closing, what will happen is that the closing attorney will prepare an affidavit that states that Joe and Mary own title as joint tenants with full rights of survivorship as set forth in the warranty deed or the limited warranty deed or the quitclaim deed recorded in deed book whatever, page whatever, and that Joe died on whatever the date was, and that his death certificate is attached to the affidavit, and then you'll have the legal description. That gets recorded in the real estate records before the deed where Mary conveys title to whoever her buyer is. And that is a simple process. When you order title, you're going to send to the closing attorney a copy of Joe's death certificate and let them know that Joe is deceased, and the closing attorney will handle it from there. On the other hand, when you look at that deed, when you're sitting down with Mary during the listing appointment, if you do not see the words as joint tenants with full rights of survivorship or some variation of that phrase, of that verbiage, then that means that Joe and Mary own the property as tenants in common. So if Joe and Mary are tenants in common and Joe passes away, that means that his interest in the property is not automatically conveyed to Mary. If you're still with me to this point, go ahead and type the word probate in the comments to let me know you're still watching. Your next question is, did Joe have a will? If Joe had a will, then that will have to be probated. So you're going to want to see a copy of the will. And the first thing that you're going to want to look for in that will is who was named as the executor of the estate. Because if it's not Mary, then Mary has no authority to sell the property, even though she and Joe were married. It might be one of their children. It might be some third party, maybe an attorney or an accountant. Those are questions that you need to ask. You're going to need to see the will to confirm the information that you're being given. Who is the executor? Once you know who the executor is, your next question will be, has the executor presented the will or offered the will for probate? If the will has not been offered for probate, the property cannot be listed, because until the court has appointed the named executor or someone else, they might say that the executor doesn't qualify to hold that position, or maybe the executor declines to act as the executor, so the court names someone else, or maybe there was an alternate executor named in the will. But until someone has legally been appointed by the court to act as executor, the property cannot be sold, it can't be listed, nothing can happen. If there is no will, then the estate would have to be administered. That means that someone would have to step up and say, I want to be the administrator of the estate, and that could be Mary or it could be someone else. And the court has to approve them. So you're going to be looking for letters testamentary, naming the executor, legally naming the executor, or letters of administration, naming the administrator. Your questions are, how did you hold title? As joint tenants or as tenants in common? Joint tenants, you're good. You don't have to worry about anything else. If they're tenants in common, you want to know whether there was a will. If there was a will, has it been offered for probate? If it's already been offered for probate, do you have the letters testamentary? You want to get a copy of the letters testamentary. You want to keep that in your file for your broker, and you want to send a copy of it to the closing attorney when you order title. If there is no will, your questions are, has a petition to probate, or I'm sorry, a petition to administer the estate been filed in the county where Joe was living at the time of his death? If so, has an administrator been appointed? If the administrator has been appointed, your next question is, do you have the letters of administration? Get a copy of those letters of administration, and that is the person who can sign the listing agreement. If there's a will, the executor is the one who will sign the listing agreement. When you're to the point of going under contract, the executor signs the contract. In a situation where there's a will, in a situation where there is no will, the administrator signs the contract. Nobody else can sign except the people who have been appointed by the court to act on behalf of the estate. Executor, if there's a will; administrator, if there is no will. It's as simple as that. Now, it may seem complicated, but understanding those two types of tenancies will go a long way in helping you manage your probate listings. And the thing about it is that in your real estate career, you might not come across a whole lot of probate situations, but understanding these concepts will so help you when you do.